Good afternoon, everyone. And first, to our speakers and to everyone here present and being part of our discussion. My name is Marta Boret. I'm honored to moderate this panel in relation to the connection between DAOs and the off-chain world. Definitely, DAOs will interact with other parties, so this should arise some conflicts or some issues that we will be discussing here today. Now I'll take this opportunity to introduce our speakers. So first we'll start with Professor Guillaume, Professor of the Lex Tech Institute. Professor Florence Guillaume will talk with us about how any future regulation should address the standing of DAOs before state courts. So we'll have the pleasure to start with that discussion. Then we'll have Guillaume, which is online hearing us. And Jamil is a lawyer, currently writing a PhD thesis on legal theory and decentralized dispute resolution systems. So we'll be very grateful to hear from you on this point, basically in relation to the blockchain-based dispute resolution and how that could be a solution in the DAO regulation. Also, Jamil worked on a report on DAO's governance, so we hopefully will have the opportunity to hear about some of your conclusions on that report. Then we will move forward to Peter. And Peter, a trained lawyer, economist, working currently at the Norges Bank and lecturing in the Oslo University. Thank you for being here, Peter. Peter will talk with us about the civil liability in relation to DAOs and the blockchain governance. So we will be very grateful to hear your thoughts on this. Then we'll have here in person João Serra de Souza, a researcher at the Lisbon DAO Observatory, a guest lecturer and a PhD candidate here at the Lisbon Faculty of Law. So thank you for being here also. And João will share his research on how knowledge attribution applies to DAOs. So basically, when you can say that a DAO knows something, and definitely this should be a very difficult issue to address. And finally, we'll have João Vieira, also a researcher at the Lisbon DAO Observatory, a professor at the Universidade de Lusófona, and a legal advisor at CNBM, Comissão de Mercados Valores Mobiliários. And João will share with us some thoughts about the relationship between DAOs and transaction costs. And we'll start with Florence. So please, you'll have the floor.
Thank you, Marta. Thank you very much. So in relation with the topic of DAOs and the off-chain world, which is the topic of this session, I think that the issue of litigation involving a DAO is a very, very interesting one in several ways. First of all, it should be noted that DAOs are subject to disputes among their members, disputes between the DAO and some of its members, and disputes with third parties such as creditors. So this is exactly the same situation as from other types of companies or any organizations of persons, regardless of its legal form. So we have already talked about this morning, but I think it's important to remember that we need to make a clear distinction between two types of DAOs. First, we can identify DAOs which are constituted and governed only by computer code. This concerns the vast majority of DAOs currently in existence. Second, there are DAOs that exist in a hybrid format, and this is what I think it is. It's a hybrid format, and they are constituted and governed not only by the computer code, but also by the corporate law of the states in which they are incorporated. There are currently a few states, notably in the United States, that have enacted a DAO law that defines the legal status for such entities. The so-called American model, adopted by Vermont, Wyoming, Tennessee, and more recently Utah, consists in attaching the DAO to a limited liability company, so LLC. DAOs that are constituted under these laws are often referred to as BBLLC. This BBLLC, you know that it stands for blockchain-based LLC. In this case, the DAO and the company are merged in the DAO, And in this case, the DAO and the company are merged, and the DAO is, after all, just a way for the company to organize itself using blockchain technology and to act in the Web3. We can refer to this type of DAO whose code is consistent with the law of the state as regulated DAOs. Other states have also passed laws on DAOs, namely Malta and the Marshall Islands. And furthermore, there are some countries where existing corporate structures can be used to create a link between the DAO and the physical world. But it's just a link between the DAO and the physical world. This is the case, for example, in Switzerland, where it is possible to attach, therefore to link a DAO to an association or foundation and use this type of structure to materialize the DAO in the physical world. Anyway, true regulated DAOs, what I can call true regulated DAOs, those are DAOs that exist in a hybrid format under the law of the state, and it's mostly the American model. They are constituted and governed by the computer code and the corporate law of the state in which they are incorporated. Such DAOs do have a legal personality granted by the law of the state in which they were incorporated. Therefore, there is no particular problem when they appear before the state courts. They can sue and be sued in their own name. As for regulated American DAOs, their treatment by the state courts is identical to that of any other company incorporated as an LLC. For this reason, I will not elaborate further on the issue of dispute resolution involving a regulated DAO, because it's exactly the same topic as for any kind of corporate corporate entity like LLCs. So what is interesting from a legal point of view is the other types of DAOs, the unregulated DAOs. Today, the vast majority of DAOs are created exclusively in the digital environment of the blockchain without any reference to a legal order. Those DAOs are not established under the law of the state and derive their existence solely from their code. This is, for example, the qualification adopted by the Californian court in the BZX DAO or the UP case DAO. And the qualification that they adopted in California was to say that those types of DAOs are usually qualified as general partnerships. So unregulated DAOs, usually they are qualified as general partnerships. There are some distinctions between different jurisdictions, but we can see in this OKI case or BZX case that the Californian court said that it is a general, or it can be qualified as a general partnership. So when a dispute involves an unregulated DAO, the question arises as to how to bring the defendant DAO before the state court. The plaintiff in the action will face several difficulties. First, it should be noted that DAOs are international entities by nature. So this is why the rules of private international law must be applied to determine in which state a DAO can sue or be sued in civil and commercial matters. Private international law rules must be used to determine which courts have jurisdiction over a dispute related to the governance of a DAO, as well as a dispute in matters relating to a contract or to a tort. But applying these rules to locate a dispute in the territory of a state is very difficult. It is almost impossible to determine where the seat of an unregulated DAO is located. There is no place of incorporation, which means that the criterion of the statutory seat or registered office fails to link an unregulated DAO to a state. Furthermore, there is no place of administration that could point to a state. The criterion of the administrative seat fails to create any link with a state because an unregulated DAO is a community of pseudonymous members who jointly manage the operations of the entity through online platforms. Thus, the criterion of the administrative seat can only point to the internet or the blockchain itself. It is therefore unlikely that state courts will be able to establish their jurisdiction over a dispute related to the governance of an unregulated DAO on the basis of the seat of the DAO. There is no seat of the DAO, no seat of an unregulated DAO, so I think that it's impossible to state three jurisdictions to admit jurisdiction on the basis of the seat. Now, if we look at the problem in contractual and tort matters, The first rule of jurisdiction to be considered is the forum of the domicile of the defendant. Generally speaking, the seat of a company is deemed to be the domicile. The seat is located at the place designated in the bylaws or articles of incorporation. However, it is very unlikely that an unregulated DAO would designate a seat in its code. Failing any statutory seat or registered office, the seat is in principle deemed to be at the place where the company is administered in fact. But as we have just seen, it is not possible to establish the administrative seat of an unregulated DAO in a state for the purpose of determining a forum. Anyway, even if a dispute of a contractual nature or for a tort involving an unregulated DAO can be linked to a state, it is unlikely that the DAO would be a party to the proceedings because such a DAO generally does not have the capacity to sue and be sued in its own name. The Bezadix DAO case, or the Uki case, is a good illustration of the problems encountered when bringing a DAO before a state court. In the lawsuit before the California courts against Bezadix DAO, the DAO has been characterized as a general partnership by plaintiff's counsel, and the lawsuit has been filed consequently against some of the DAO partners. This qualification means that the partners are jointly and severally liable for the debts contracted within the framework of the DAO. In a very recent preliminary order, the court admitted that the qualification of general partnership is acceptable. It also stated that the token holders are all members of the general partnership and are, for this reason, responsible for the acts of the DAO as members of a general partnership. I think that this legal regime is not really fit for DAOs, as it will imply to expect from the members of an unregulated DAO to be liable beyond their original contribution. It seems to me that it would go too far to consider that the simple fact of having tokens that grant voting rights in the DAO's governance leads to an unlimited financial responsibility, especially when the DAO has thousands of pseudonymous members. But this is a risk that faces DAO members for the time being. It must be added that challenges to seeking justice in case of a dispute involving DAOs do not end with finding court with jurisdiction over the dispute. Even if state court has jurisdiction and renders a decision, the aggrieved party may find it impossible to seek the enforcement of the decision when the losing party does not comply spontaneously. The immutability that characterizes blockchain technology does not allow any authority to modify the content of the blockchain ledger. Hence, state authorities have no enforcement power over crypto assets. The DAO's crypto assets cannot be frozen, seized, or confiscated. State authorities cannot force an action upon the DAO either. Only the community of members acting within the parameters of the code can trigger an action from the entity. In other words, the enforcement of a judgment rendered by a state court can only happen with the cooperation of the losing party. This leads to a significant risk of non-compliance with the judgment because people know that coercive enforcement is not a realistic possibility. Since a state has no power to enforce a judgment rendered by its courts on the blockchain, the efficiency of justice cannot be guaranteed. However, it is true that a court could order a compensation, such as the payment of damages, to circumvent the impossibility of enforcement on the blockchain. As long as the members of the DAO are individuals who can be identified, it is also possible to exert pressure on them to get voluntary enforcement of a court order. Of course, when a DAO wants to bring a claim before a state court, it will face the same difficulties. In particular, the fact that it does not have legal personality prevents it from filing a lawsuit itself. In the blockchain environment, the anonymity of the parties is also an impediment to filing a lawsuit. It is indeed not possible to sue a person whose identity is not known. That said, it is becoming more and more easy to determine the identity of a person who uses the blockchain. but identifying a user is still complicated and very expensive. It is therefore necessary that the financial claim is important enough to justify the costs related to the identification of a user. If this is not the case, the anonymity of the parties is often a significant problem for access to justice. In any case, legal proceedings involving a DAO are long and costly, and they give rise to delicate questions as to jurisdiction and applicable law. There is also a significant risk associated with international enforcement of the judgment. State courts cannot guarantee access to justice in a reliable manner for disputes involving a DAO. Thus, there is a great risk of denial of justice in this matter. In conclusion, I can say that I do think that DAOs play and will play a key role in the ever-growing crypto economy and the development of DeFi. They deserve, as such, a legal status. Granting DAOs legal status is necessary to provide some legal certainty in this environment, not only for the members and participants of DAOs, but also for third parties who enter into legal relationships with DAOs, such as creditors. It should be remembered that generally only a DAO with legal personality has the capacity to sue and be sued, to carry on business activities, and to enter into contractual relationships in their own name. Access to state courts is therefore, in most jurisdictions, only possible for DAOs that have legal personality. For all DAOs without legal personality, access to justice is only available through online dispute resolution, but the decisions rendered by those mechanisms do not have the same authority as a judgment rendered by a state court and cannot be directly enforced with the help of state enforcement authorities.
Thank you so much.